Today is April 4th, 2017, and we are located in the judge's conference room on the second floor of the Garmatz Federal Courthouse. We are here to conduct the oral history of the Honorable Frederic N. Smalkin, and my name is Ty Kelly. I was his last law clerk, and I am grateful to be here to do this today. Good morning, Judge.
Good morning, Ty.
How you doing?
I'm fine, thank you. Thank you for putting up with an old guy to do this. I appreciate it.
Well, I can tell you the honor has been mine as I've gotten to know a lot more about your history as we've gone through this process.
Well, remember the parts of it we're keeping secret.
I promise not to go into those.
All right, good.
Let's start with your pre-court history. Where did you grow up and where did you go to school?
I grew up in Baltimore County. My parents had lived there all their lives, and my father was a lawyer in Towson in the days when there weren't very many. I think when he joined the Baltimore County Bar Association, he was the 35th member. Now, when they have their annual bash, I think they've got to hire out probably the biggest hall in town. They're in the thousands. It's just hard to believe what's happened to Towson. I remember going down to Towson with him, and the old Ma and Pa Railroad still crossed York Road. You can still see the sort of the stone pillars that held the trestle of the bridge up that went over York Road. And I used to love to go down and watch the trolleys go up down York Road and the steam train go over top of it. And those were the days. And then he became a judge in the county and died when I was very young. I was 11 when he died. And I decided I'd like to be a lawyer like him someday. And of course he had as was the case then, the lawyers had a lot of rural clients. And I can remember him coming home in his got it first, you could get it after the war when they started making cars again. I think it was 1949, big Buick. And in the trunk, every now and then he'd have a live turkey, which my grandmother would take out in the back and wring its neck and pluck it. And then potatoes and onions and all kinds of things, because of a lot of the farmers didn't pay in cash in those days, barter economy still. So I thought, well, when I get out of school, I went to McDonough school for 12 years. It was then an all-boys military school. And so when I got out, went to college at Johns Hopkins University. And I, all the time, wanted to be a lawyer. I sort of wanted to be a country lawyer like him. And I thought, well, we'll bring home the occasional turkey. But things changed. And that's not just exactly where I wound up. But that was my sort of early thing. So I thought I'd always be a lawyer, and that's what happened eventually.
Well, before we go on to when you started law school, let's talk about when you were a game warden in college.
Yes, that was one of the more unusual jobs that I had, and probably the most fun. I think when a lot of people look back at jobs they had when they were young, they think how wonderful they were. But things have changed so much. I mean, there aren't any deputy game wardens anymore because life is so complicated, just like there are hardly any deputy sheriffs that you put together to form a posse anymore, that they're just not there. But in those days, I was working for the Maryland Game and Inland Fish Commission, which has now changed names to something or other. It's something much more modern. And I got a job working at Glenbrook. And Glenbrook was in those days, there were so few deer that the state actually raised deer to let loose, to put deer out there so people could go hunting. Now, of course, deer are, constantly your cars running into them, and they're eating all the expensive bushes out of the McMansions in Baltimore County. So we're overrun with them. But in those days, there were hardly any. And so I was doing some kind of clerical type work and whatever, but I would ride with the game wardens every now and then. We only had 2 up in the county, and one of them said, well, I'd like to make you my deputy. And I said, well, that would sort of be interesting. He said, do you mind going out and working at night? Because we had a lot of what are called light, you'd call them jackers, I guess. They would shine lights on the field and shoot the deer. You know, they absolutely stuns them, and then just shoot the deer at night, which was highly illegal. So we used to go out and look for that. We'd catch them every now and then. And so I said, okay, yeah, I'd like to be a deputy. And he said, okay, well, we'll send your name in. Well, about 2 weeks later, I got a letter from George Shields, who ran the thing. And he said, I'm happy to commission you a Maryland State Deputy Game Warden with statewide privileges, he said, and so take this letter to the Circuit Court for Baltimore County with $5. I thought, well, okay. So I went to Towson, and I went down to the clerk of the Circuit Court, and she says, oh, you're the one that's going to get the game warden stuff. And I said, yes. So she said, well, first you have to sign the test book and take the oath. So I signed the test book, and I took the oath, and she said, here, and she gave me a shoebox, and in the box, I had my own gun, but in the shoebox there was a ticket book and a book of the game laws of Maryland, and that was my training. So I took the shoebox home and I read it. I pretty well knew what they were anyway, and that's the way, you know, it was before police training got very fancy, and next thing you know, after I paid the $5, I walked out as a deputy game warden. And we had an awful lot of good times together. These were two wonderful guys I worked with. And then I came to know Willie Parker, who was the sort of central attraction at what I understand, and I did actually see it, was a terrific display put on by Herbie Better, whom we both know, and who's very much the center around whom our historic operations work here in the court. And Herbie put out something about the entire Fish and Wildlife Service. Well, the way it was in the old days. It's not quite as busy here as it used to be because we don't have as much land and as much game as we used to have. But Willie Parker was a game warden par excellence, known all over the United States. And so Willie said once, he said, well, he said, you're one of Paul Little's deputies, why don't you take a federal deputy's commission? I said, well, that's nice, what do I have to do? He said, sign the paper here and we'll send you a badge.
Did you have to pay any money?
No, that one was free. That was, the federal one was free, the state one cost $5. That was the test oath. Everybody who took an oath had to pay $5. So the state taxed, they probably should go back to doing that. Anyway, so I worked with Willie and we had some really good times, and he was quite something. He was a legend, truly. He wrote 2 books, both of which of course I have, and I remember when he retired I was still flying my own airplane, and I flew down there with Chick Getz, who was another one of the U.S. magistrates, to Willie Parker's retirement, and Larry Thurman, who was one of the game wardens that Willie worked with. We flew down there to bid him a happy retirement and had a great time. We, despite my flying, got there and got back all in one piece. So we had a chance to see Willie when he retired, and that was quite, but we had some really interesting times, I must say. It was a great job.
I bet. And after that you went on to the University of Maryland.
Went to the University of Maryland Law School, yeah, where my father had gone as well.
And where you graduated first in your class.
Well, that's what they say.
I think it's probably true.
Yeah.
And this is about the same time that you had a very decorated and esteemed military career.
Well, yeah, when I was in college at Hopkins, the Vietnam War was going on. And I remember my father, who died when I was very young, I was only 11 when he died. I remember sitting in his car in the Buick, same one that hauled the turkeys and the potatoes around. And I must have been maybe 9 or 10, and he said, there's 3 things I want you to remember, and I've remembered them all my life. The first thing he said was, don't smoke cigarettes. They don't call them coffin nails for no reason. I didn't pay any attention to that. Smoked like a chimney. So then he said, don't ever write anything down that you don't want to see written in the front page of the Sun paper the next morning. I remembered that one. Mostly, until I became a judge, I guess. And then he said, if you have to go in the Army, be an officer. And I remembered that one. So I took ROTC at Hopkins. I did pretty well there. When I graduated, I was given a regular Army commission in the Ordnance Corps, and I started to get ready for the Ordnance Corps, take the training and all of that stuff. And then I went to law school. They gave me a thing called excess leave to go to law school. And it was a new program they were trying out for people they thought would be maybe fodder for career military service as a lawyer, which sounded like something nice to me. So they wouldn't pay for law school. They put me on leave. They called it excess leave, which is another way of saying you don't get paid. Leave without pay. So I went to the University of Maryland Law School, was admitted there, and didn't get any salary, had to work part-time to make ends meet. But I will say the tuition was not burdensome. The tuition was $150 a semester, and it was well worth it. And I think the tuition cost more than the books every semester. So I managed to do that. I still had a house to live in here, and that wasn't a problem. So at the end of towards the end of the third year, and I was getting ready to go back into the Army, because at leave time and during the summer, I put the uniform back on and I went and did Army stuff, and I actually got paid for that. The munificent sum of $222 a month, plus non-taxable $78 for food and a couple $100 for housing allowance. So, but 200 some bucks was in those days equivalent of, I guess, 2,000 now. Anyway, so as the end of my legal education was in sight, got a call from, or not a call, I guess, a summons to come down and see Professor Russell Reno. And Russell Reno was one of the gods of the school in those days. A wonderful guy. He had been an officer in World War I, and he was also a colonel in World War II, so in the Guard. And so we called him Colonel Reno, and Reno called me into his office, and he says, do you know who Judge Northrop is? And I said, yes, yes sir, he's the head judge, federal judge in Maryland. He said, well, he wants you to come over and see him. I said, well, could you tell me why? He said, well, traditionally the person that finishes first in the class, he likes to see them and likes to hire them as a law clerk. I said, well, I can't do that. I've got to go in the Army. He says, well, go over and see him anyway. So I did. And we shook hands, and he looks at me and he said, I've read your transcripts from college and law school. Can you type? And I said, yes, sir, I can. He says, you're hired. I said, wait a minute. I said, I appreciate your confidence, but there's a little trouble. I've got to go right into the Army after this. He said, well, we'll see if we can't fix that. So after a few calls to headquarters in Washington, it was worked out that once again I would have a year's postponement and be his law clerk. And I did that. I was only the second one in the history of the JAG Corps to do that. Actually, I never got in the JAG Corps. I was in the Ordnance Corps the whole time, but they forgot to transfer me. Anyway, so the other person that was doing it at the time was Bob Mayer, who became Chief Judge of the Federal Circuit. And there also, of the other people I worked with while I was actually in the Army, Royce Lamberth, who became Chief Judge he was an Assistant U.S. Attorney in D.C. and then became Chief Judge of the U.S. District Court in D.C. And a couple of other went on to become federal judges. So then I was in the Army for a while. I wound up, my last job was as assistant to the General Counsel of the Army, which was a very interesting job. Did an awful lot of wonderful stuff, some I still can't talk about, I think. And then when I came out, I was going to go to Piper and Marbury, which is where I worked when I was in law school, to try to make a couple bucks. And had a letter all ready to send to Roger Redden, who was then in charge of hiring at Piper. And I went to, I got a call from Judge Northrop. And he said, George Burgess, who was then one of the U.S. magistrates. You called them U.S. commissioners in those days, but I think he had just become U.S. magistrate. That title had just come in. Is going to retire, and I'd like you to take that job. And it's down in Hyattsville. And I wasn't really keen on moving to Hyattsville, but he said, yeah, but well, you'd get up to Baltimore and have you work there. I want somebody who does not come out of a criminal law background, but somebody who's done some civil work like you have with me and in the Army. I did litigation and stuff in the Army too. And I said, well, I was ready to go back to Piper and Marbury. He said, yeah, but I really want you here to build up this new magistrate thing so that it can help the judges with civil work. And I thought about it for a while, and I thought about it, and eventually I said, well, okay, I think if you'll have me, I'll do it. Well, then George Burgess decided not to retire. So I thought, well, here I go, I'll write the letter to Roger Redden, which I still had in my desk drawer. And then a couple of weeks later, Judge called me and said, yeah, well, George is going to retire. So I came on as a U.S. magistrate. That was in October of '76. Before I did that, I did some private practice. I had a couple of rich friends and clients who got in difficulty every now and then, so I did some work for them. And then when the opening came up, in those days there, as you can tell with me, no merit selection for judges, for magistrate judges, and it was the chief judge's prerogative. I think he had to get the votes of the others, but that was easy because there were only, when I came on, when I worked for Judge Northrop, there were 3 U.S. district judges. Then Jim Miller came on, and then Stan Blair and Joe Young, and during the Nixon administration. So they didn't have any problem. I came on and sworn in and started working.
Well, before we get to your time as a magistrate, give us a flavor of clerking for Judge Northrop.
Well, he was what the Brits would call a one-off. They only made one of Ed Northrop. And it was just very hard to describe him in all of his facets. He had more facets than that lovely diamond ring you're wearing. He was a scholar, a historian, a naval officer, went all the way through World War II from ensign to full commander, had one of the most fascinating war careers. I don't know if you got a video from him before he passed away, but his World War II career was amazing. He was a politician and was a very high-ranking politician in Maryland. He was the majority leader of the Maryland Senate back when the Senate only had 24 members. It was before reapportionment of the upper house in Baker versus Carr. So each county had one senator, and the city of Baltimore had one senator. And the senator from the county ran the politics of the county, which then, as now, was predominantly controlled by the Democratic Party. And Ed was a Democrat. And when John F. Kennedy came in, there was a new position created for the 3rd judge in Maryland. There have been 2, been 1 for a long time. Then when Prohibition came in, they put in 2. Then there was a need for 3 because the business was getting bigger. So in 1961, I think he got the appointment as U.S. District Judge under John Kennedy. And he was very sage. He understood people very, very well. And he could read them very, very well. And he also had a great sense of fairness. And he understood how politics works. I can remember him telling me a number of things that stuck with me. And I know one that stuck with you that I told you. Among other things, he had talked about the fact that politics is like a pendulum. It will always swing from one side to another, and we've seen that in our lifetimes for sure. And then before I get to the other thing, he told me, he said when he had first become a judge, he didn't know quite what to make of it, and he thought, well, you have to think about all these things very seriously, and of course the caseload piled up the more he thought. And one day he was sitting in his chambers and he had his feet up on the radiator looking out the window. And Chief Judge Roswell Thompson came in, and Judge Roswell Thompson was a ball of fire. And he came in and he saw Judge Northrop sort of looking out the window with his feet crossed on the radiator, and he said, "Northrop, what are you doing?" And Judge Northrop said, "Well, Chief, I'm thinking." And the judge says, well, I says, get busy, get to work. We don't have time for thinking around here. that was his initiation. And one of the things he told me, and which I passed on to you, and I remember we talked about this the other day, and you remembered it well, was he says, you know, you can't, as a district judge, always be right. He says, you know, and our job here is to be decisive. It's up to the Fourth Circuit to be right all the time, but our job is to be decisive. And I think that is something I've thought about for a long time, and it still is the case, because in the district court is where the case is made or lost. You know, I have a saying I tell my students, I probably shouldn't say this because someday a judge of the Court of Appeals might watch it, but in any event, I said the thing to remember is appeals are for losers. So you want to win your case in the district court. And actually, one of the students once had a T-shirt made for me that said "Appeals are for losers." I don't know what I ever did with that, but in any event, so I remember that, and he was just a wonderful guy. You could not find someone who would speak ill of him.
I can still remember the day when you gave me the advice of that we're paid to get it right, and the Fourth Circuit is paid to get it. I'm sorry, we're paid to do it, and the Fourth Circuit is paid to get it right.
You should have said get it wrong, but
right. Okay, so moving on to when you became appointed a U.S. magistrate. As I understand it, the magistrates at the time were doing all criminal work.
Yeah, they were U.S. The old title had been U.S. Commissioner, and nobody knew exactly what a U.S. Commissioner was except a U.S. Commissioner, and the U.S. attorneys, and of course the field agents. And there were a couple of full-time commissioners, and there were some part-time commissioners. Many of them were truly part-time, and there was, and still is in the magistrates world, a schedule of full-time, half-time, et cetera, and it goes down to, I think, 1/16th time or 1/8 time. And those would be magistrates that basically take care of parks where there is very little federal activity except for something that might go on in a park. So they need somebody to take care of the petty crimes that occur. The commissioners and then the magistrates, when the title changed in 70-something, I think it might have been, no, and it had to be, well, maybe in the late 60s, early 70s, there was a law passed creating the job of U.S. magistrate and converting the commissioner's job to that, and then adding a number of things to it, including civil work. But the commissioner's job and the early magistrate's jobs, and they had mostly come from a criminal law background. Here, when I got here, the other magistrates were Chick Getz, who had been an assistant U.S. attorney, and Paul Rosenberg, also assistant U.S. attorney, both of whom were terrific people. They were the full-time people. And then we had somebody up in Aberdeen, we had somebody way out in Western Maryland, and somebody on the Eastern Shore. And they were there primarily because there were federal agents on the shore and in Western Maryland, and we also had one down in Southern Maryland. And they at times would need warrants, and the commissioners were empowered to issue all kinds of warrants. They were also issued or able to hold preliminary hearings and bond hearings, set bond and things like that, and also try petty crimes, misdemeanor offenses. For example, some of the military reservations were within exclusive military jurisdiction, so the offenses had to be tried by a federal officer, and the U.S. commissioners did that. So that's pretty much what the magistrates were doing here, and Judge Northrup told me, look, I want somebody to start a program taking care of the broader jurisdiction that's been given to magistrates, and that would include things like motions, taking care of discovery disputes, non-dispositive and dispositive motions. On the dispositive motions, the magistrate judges, because they weren't Article III judges, could not make definitive rulings, but they could make recommendations and reports to the district judges. Then another thing that I did was to shepherd the commissions on land takings. And the rules in those days, and I think there are still the rules, are that there is not generally a de novo proceeding in the district court when there's condemnation by the U.S. government, but there is a group of equitable officers, commissioners, most of whom have had real estate or been lawyers that value the property, but they have they also sometimes utilize juries. It's a very interesting procedure, and at that time there were two huge government taking things going on. One was the C&O Canal and acquiring the land that was bordering it, and the other, and that had a lot of complications with it, and the other was the Washington Metro system. And it's hard now that I look back on it to believe that the Metro hadn't even been built then. They were taking the land to build the Metro system on when it came into Maryland, PG and Montgomery County. That's when we got involved in it. And it was complicated because some of the parcels that you were taking were little tiny things that were sort of remnants of somebody's land grant. Others of them were big places with stores and things on them and whatever. So we did that, and then I started doing settlement conferences, which I understand the magistrates still do here, and they do it quite well. And to me, it was, sort of a learning experience because nobody had done them before. The judges, in those days, the idea of a settlement conference was just before the trial started and before the voir dire came in, the judge would have you in chambers and said, "Are you guys going to settle this case?" "No." "Okay, let's go." That was it.
Wow, how things have changed.
Yeah, things have changed, exactly. So that was the beginning of the magistrate system, and there were relatively few of us across the country that did that civil type work. I shouldn't tell this to a former stellar assistant U.S. attorney, but I never really cared a whole lot for the criminal stuff. It's just all right and it's interesting, but to me the civil stuff was more fun, and you could be a little more creative, I think. Well, I guess in my sentencing, I was sometimes creative, and sometimes the U.S. attorney didn't like it. Sometimes the public defender didn't like it, but it's that old thing about judges ask, "What kind of judge are you?" and they expect the answer to be, "Well, I'm a state district court judge, or I'm a judge of the Court of Appeals." And I used to say, that depends on whom you ask. About 50% of the people, in fact, exactly 50% of the people that walk out of my courtroom think I'm the second coming of Oliver Wendell Holmes. The other 50% wonder how somebody as dumb as I got the job. And that's about how it works. So anyway, civil work was more interesting to me, and I did that for about 10 years, and then the Republicans got back in, and I was a lifelong Republican, and people suggested I attempt to become a district judge, and that had become a little more difficult because the judges then at that time started to be chosen by merit panels that the senators put in place. And when I was coming up for consideration in the late 80s, the two senators were Mac Mathias and Paul Sarbanes, and of course Mac was a Republican and Paul was a Democrat. But because there was a Republican administration, the Republican senator had to call, and there were a number of people that I knew were certainly ahead of me in terms of age and experience, and also affiliation, active affiliation with the party, and they got appointed, and that was fine. You expect that to happen, and they're wonderful people. I miss them today, including John Hargrove, who was just a delightful person, and Walter Black, who was just also a wonderful, delightful person who died fairly recently. John perished a few years ago. And then finally, I thought I was in line, and then Judge Motz decided he'd like to be a judge, and of course he had seniority over me and had been a U.S. attorney and more active with the party, and then I was fortunate enough to get the one after that.
Before that, tell us about your chambers when you were a magistrate judge. You had the same secretary all of your years on the bench, that wonderful, wonderful woman that I had the honor to know. Tell us about your chambers.
Sue Parker. Well, when we started, we were in the old building, which is now called the Baltimore Courthouse East, I think. And the post office, the entire main United States Post Office for Baltimore was the first 2 floors of that building, if you can imagine that. And the second floor was offices of some sort. Third, fourth, and fifth were a part of the court. And so when we started, the only place to stick us, this is in 1986. Now, when did I start? No, 1976. 1976. Before we had moved to the Palais de Justice here on Lombard Street. The only place that they could put us was in a jury room. And it was a disused jury room at that. And there was one small desk for me and one small desk for Sue, and we sort of faced each other, but it did have a men's room and a woman's room in it. Not that there was a whole lot of men and women coming through the jury room to use it, but it did have two bathrooms. It had one small room and two bathrooms, each of which was larger than the room. But anyway, we were there for a while, and then we came over here to this building, and I certainly remember the agonies that Judge Northrup, who was then Chief Judge, went through with the construction of this building and the mini courtroom thing that was going around, because the Chief Justice at the time thought that he had taken a trip to England where there were a lot of smaller courtrooms, and he thought we didn't need big ones. So we had a lot of mini courtrooms until they were torn out eventually and replaced with real courtrooms. And the one thing that I have to credit Judge Northrup for was he said, I'm not going to have a building where you can't open at least some of the windows. So fortunately, some of the windows in here do open, and that's Judge Northrup should have his name engraved out there for having done that. It's very difficult to deal with the General Services Administration, which was in charge of building. And I remember, I've got to put this in, it's such a great story about Judge Northrup. I was in his chambers, and I was a magistrate then, and we were over in the old building, and he was having one of his constant running battles with the GSA about this building. So he couldn't get an answer. Finally, he called and he got through to the administrator, the chief of the GSA, who was a retired Rear Admiral. Judge Northrup was a retired commander. So they had a nice little conversation, talked about their years in the Navy and World War II, and Judge Northrup said, you've got to help me. I can't do a thing with these people that work for you. And then Judge Northrup got the funniest look on his face, and he said, really? Oh, well, I don't know what to say. Good luck. It's been nice talking to you. And he hung up the phone. And he turned to me and said, well, you heard me say I couldn't get anything out of the people that work for him, didn't you? I said, Freddie? I said, yes, sir. He says, well, he said, yeah, it's the same with me, which is why I'm quitting next week. And then he hung up the phone. Well, anyway, so we moved into the new building, and that was that, and went on to other things.
You moved into this courthouse when you were a magistrate?
Yeah,
Got
I
it.
still was, yeah.
So set the stage for us. Whose seat did you take on the district court?
Well, that was Judge Jim Miller, who unfortunately passed away fairly recently, and Jim was a fantastic person. He had been active in Republican politics down in Montgomery County. Just absolutely lovely, wonderful man. And he got sick. He had some very bad heart problems, so he retired, and that opened up a vacancy, and I took his vacancy. And as I say, it was a very hard seat to fill because such a terrific guy. And we also had John Hargrove as a Republican appointee. Now, Jim was before that. Jim came in the Nixon era. John and Walter came in the Reagan era. Joe Young came in the Nixon era, yes, in the Nixon era as well. And Stanley Blair came in the Nixon era. Stanley Blair was a good friend of Spyro Agnew's, and so he had some connections. Stanley was a wonderful guy as well, so they were all here. So replacing Jim, it was, you can't replace him. You take his seat, but you can't replace him, and he was just a terrific person. As were the other people. Stanley Blair, who can ever forget Stanley Blair? And he was, I remember he lived in Darlington, and Darlington is way up in Harford County, up on the Susquehanna River, had a beautiful farm on the Susquehanna River. And because it was such a long trip, and he was such an assiduous worker, in the old building and in the new building, he had some beds put in, a bed put into his chambers so he could sleep overnight when he had to work, or be in early in the morning, and he just wouldn't go home to Darlington. And Stanley used to, I don't think he slept very, very well, and he used to get up and occasionally at night and walk around, put on a bathrobe and walk around the courthouse. And in those days, the old courthouse, we had parking in the garage, which they've still got in the city courthouse, now the city courthouse east. And we had the GSA police at that time. Now there's some part of DHS and whatever, but the GSA police would be on guard at the courthouse. And there was a little booth that's still there that the sheriffs use, that the GSA guard on duty would use at night. Well, we had this one fellow who had the habit of falling asleep on guard duty. And Stanley walked down into the garage and was going to go talk to him a little bit. It was maybe 2 o'clock in the morning, and Stanley noticed he was asleep. So, Stanley having military experience, the old thing was if you were caught asleep on guard duty, you were shot. Well, of course, Stanley didn't shoot him, but Stanley went and took his revolver right out of the holster, stuck it in the pocket of his robe, and he wrote him a little note. If you want your revolver, come see Judge Blair first thing in the morning. Stuck it in the holster.
I bet that was his last night on duty.
That was his last night on guard duty, yes. He got day shift after that, where they could keep an eye on him. So that was just one of Stanley's things. And I remember Stanley telling me, he says, you don't want to be a judge, do you? He said, well, I thought, well, someday maybe judge. He says, don't do it, because if I could switch jobs with you, I would. Well, I didn't listen to that, and later became a judge. But anyway, that was Stanley Blair.
And when you came on as a district judge, there was just one courthouse. There weren't 2 separate divisions.
That's right. We didn't have the Greenbelt division. There was a lot of, I won't say acrimonious, but heated discussion politically and within the court about what to do with this. And I think that a lot of it, and I guess I can speak freely now because a lot of the players are dead, but a lot of it had to do with the politics of the situation and the fact that I think there was a feeling in Montgomery and Prince George's County, which were growing in population and in legal population as well as population itself. As they were growing, they thought that coming up to Baltimore was difficult, and it was difficult for them. It's still difficult to get from Baltimore to Greenbelt or Rockville. But not only that, they thought that the Baltimore bar had sort of an inside entree to the court. They were closer. They were therefore hired perhaps more for doing federal work. The number of lawyers who did federal work was way smaller than it was today. They get all of them in this room, really, and have room left over. From a few of the big firms in Baltimore primarily, and some of the specialties like bankruptcy. Anyway, the writing was on the wall to most of us that there was going to be something built in Greenbelt or Rockville, somewhere down in the southern area. And the question was it going to be a district court of itself or a division? And I'm not going to get into names, but some of us were very strongly set on the idea that, look, this is inevitable. We're going to have it. It's a political necessity, and we're going to have it. And we should. There were a few of us, including, I will say, Norman Ramsey, who was another wonderful human being and a terrific lawyer and judge, and Walter Black and myself, and Judge Northrup, who said, well, we ought to sit down and work out a good way for this to be done. Well, and it turned out eventually that instead of there being a separate district, there was basically a branch office, Greenbelt, put down there. And it's obviously worked out quite well. And if it had been a division, of course, it would have been more expensive for Congress because there would have had to been a United States, another clerk, full-time clerk of court appointed. There same number of judges, 3 judges, but there would have had to been another U.S. Marshal, another U.S. Attorney, et cetera, and that gets more expensive. And so it's worked out fine, and the people down in Greenbelt do a fantastic job, both from the clerk's office and the judges who have been down there. It's big workload, lots of urban area, especially in Prince George's County, just like we have urban area here, and so that's the story of the Greenbelt Division, or a short version thereof.
So ultimately, the decision was made to have a Southern Division of the Maryland District Court.
Yeah, it was, and I think I might have misspoken a little bit earlier about this. Actually, it was the district court would have been a result that some of the judges thought was appropriate, to have a separate district, but not a division. The district court, however, would not have been practical monetarily for Congress, because they'd have to make a new position for clerk. Probably would have more judges and magistrates, and also would have to have a separate U.S. attorney, separate U.S. marshal, and it would have been a very expensive kind of thing. And I thought that they therefore decided that a division was the appropriate way to handle it. And there are divisions in larger districts in the rest of the country.
Who was the clerk of court when you were on the bench?
Well, Paul Schlitz was the first one, and Paul is still alive. I think he's 94 or 5. I know his son quite well and see his son. And Paul is as sharp as he was when I first started. Paul had been here a very long time. Paul was in the Army as a young man, 18 or 19, in going into Germany after this would be in the period as they were going through Belgium into Germany. He got shot. He was 18 or 19 years old, was returned to the United States, put in the hospital. Then through the GI Bill, he finished his education and became a lawyer, and eventually wound up, God bless you, wound up working here as clerk of court, and did a terrific job. And he kept things running very, very well, and a very, very hard worker. And a neighbor of mine, actually, out in the North County. So I got to know him, and I got to know Paul Jr. when he was a young man. And Paul ran a wonderful operation. He also had to supervise the coming into here, which he did. And then he was here until, I think, Judge Kaufman became chief judge. So he was here for a while.
Well, you intimated about your feelings on criminal law. Tell us how the implementation of the federal sentencing guidelines changed.
Oh yes, one of my favorite topics. Well, the sentencing guidelines were, of course, enacted in 1984. It was the perfect storm congressionally, because you had a majority leader, Strom Thurmond, who basically thought everybody ought to go to jail forever. He's dead too, so I can talk about him. And then you had a minority leader, Teddy Kennedy, who thought nobody ever got to go to jail ever. So they put their 2 legislative assistants on it. They are still around. One of them is Steve Breyer, who is a justice of the Supreme Court, and another, Billy Wilkins, who is a retired Fourth Circuit judge, a chief judge. And they and many others in Congress worked out this Truth in Sentencing, or we called it sentencing formal title, Sentencing Reform Act of 1986, I guess it was. Went into effect in 87, or is it 84? 1984. Went into effect in 86 or 7. It had to have a long period before it actually was applied. And I remember when I first read the draft of what was going on, I was still a magistrate judge. They didn't call magistrate judge then, magistrate. And I was scheduled to give a talk to the Federal Bar Association about this thing. And I started reading excerpts from it, and I picked out the one, I still remember, I think it was 5G, something or other that had to do with running sentences consecutively or concurrently. And I started reading the thing, and about halfway through it, people started laughing hysterically because they thought I had made it up. It was so ridiculously complex and unfathomable. And I stopped and I looked at it and said, no, this is not a joke. I couldn't make up anything like this. This is real, and this is what you're going to be dealing with when this all goes into effect. And the laughter stopped and the crying started. So the thing eventually went into effect. We here in this district, I would say unanimously thought the thing was unconstitutional from the get-go. So we sat, and I think Fred Motz was chief then, we sat en banc at a hearing, which probably had not been done since 1789 in this place, and at a hearing for a sentencing hearing. And an opinion was rendered, signed by all 10 of us that were active judges, essentially holding the Sentencing Reform Act, unconstitutional on several grounds. Well, it got down to Richmond, and there was a one-paragraph per curiam, sort of like, you guys aren't smoking the evidence or anything here in Baltimore, are you? And they said, you're kidding, this is perfectly constitutional. And so on it went for many years. And then as I was retiring, the Apprendi case went before the Supreme Court, and as everybody now knows, the Supreme Court said, after 20 years or so, gee, the Sentencing Reform Act of 1984 is unconstitutional. So it was sort of one of these, I told you so, or as the Brits say, revenge is a taste most appreciated when eaten cold. So in any event, I don't know whether you'd call it revenge, but we did get finally, our position was endorsed by a higher authority, should I say, and that was the Sentencing Reform Act. And I frankly used to go home in the evenings, and I would say, you know, maybe this is stretching it way too far, and I don't want to offend anybody, but I would say, you know, I felt like on some days the German judges in the early part of the 30s, before things got, we got into war, and even before the doctrines, the Chronicles of Nuremberg, or the proclamations, I guess, of Nuremberg, at the time when the law basically gave judges the duty to put an oath of, or to put a sentence of execution on people that were unfit, old, or had mental disease, and they had to sign papers executing these people. And that was the law, you know, and so what do you follow? You take an oath to do the law, to follow the law. That was the law. Also, you are a human being, and how do you feel when you do things that, you know, follow the law, but yet you feel at the heart of you are unjust? Well, if you ever watched the movie Judgment at Nuremberg with Maximilian Schell and Spencer Tracy, and I forgot who played the German judge, it's a good thing to watch. In any event, all judges and would-be judges ought to watch it. In any event, Sentencing Reform Act went away, and I became a lot happier, but I was retired by then, so that's that on the Sentencing Reform Act. And I think if you look today, even in Congress, they are beginning to feel like, gee, maybe it wasn't a good idea to put all of those people in jail for a very, very long time. And of course, before the end of his regime, President Obama did pardon many people who were sentenced under the mandatory provisions of that and other statutes, and showed that the thing that got to me most about the Sentencing Reform Act was the provision in black letter law that Congress put in there that rehabilitation is not a goal of a punishment under the provisions of this act. It was actually in there in black and white. So they essentially just said warehouse them. Some people, unfortunately, do need to be warehoused, but in those days judges had the discretion to do that or not. And if you exercised your discretion, you felt there was a really good reason for it and it was the right thing to do. And even before the Sentencing Reform Act, we used to get reports quadrennially, biennially, annually, I've forgotten, from our probation office that would show what the national and the local and your own personal statistics were for sentencing major crimes, the ones that the Sentencing Reform Act was most concerned with, and we were almost always within one standard deviation from one another and from the national and the local medians that were the measures that were being used, a sort of a bell curve kind of thing. So it was not a system that was out of control before. It was a system in which we paid attention to what, is a fair sentence. Anyway, that's the end of that unfortunate thing, and that went away, and so did I.
Let's talk about some of the more interesting and famous cases while you were on the bench. Tell us about the Mandel case.
Well, yes, that was interesting. My first involvement with that was right at the very beginning of it, when the jury selection was going on. All of the district judges had recused themselves from the case because they all knew Marvin Mandel because, let's face it, I mean, I'm not going to hide a ball that is sort of out there for everybody to see. Everybody understands that all judges, before they become judges, almost all judges, at least in those days, had some political ties, and a lot of people had some kind of ties with Marvin Mandel. I know, for example, when Judge Northrup was down there as Majority Leader of the Senate, I think Marvin was President of the Senate, or no, Speaker of the House, I think. So yeah, everybody knew him. So anyway, they brought in a judge from out of town, I think from Ohio, a judge named Robert Taylor, I think it was, quite elderly, and I think he was a senior judge. And so at that time, the magistrate judges were thought to have the power to do voir dires with consent of the parties, which we did. So I did a part of the voir dire and whatever. And then the trial started. I did, it's going on. When you're here, you don't pay much attention to what's going on. You do your own work. So I did my own work, and eventually Marvin was convicted. And the problem for the government was that they tried him under a statute, and I think it was a interstate use of wires, or interstate commerce, use of means of interstate commerce to commit a fraudulent act or to deprive someone of property, this, that, and the other. And they were not able to bring forth evidence of a quid pro quo kind of bribe. They thought there was one there, but it couldn't be produced, so the jury was instructed, and the defendants were convicted on the theory that there did not have to be any proof of a quid pro quo, and that the government did not have to prove deprivation of any goods, chattels, or anything of money, but simply of the public's right to have good government,
right.
Honest government. And so at the time, Marvin and the other people involved were sentenced. That was the law, apparently, and went to the Fourth Circuit. The Fourth Circuit said, yeah, that's the law. Went to the Supreme Court. Supreme Court, I don't think, reviewed it at all. I think cert was denied. Cert was taken. So things went on for a while, and Marvin went to jail for a while, and then he got out, and I think President Reagan either commuted his sentence. I don't think he got a full pardon. I think it was commuted his sentence. So Marvin's out of jail, and then the Supreme Court decides another case called McNally. And in McNally, they basically said that this statute, which went back a long, long time, never did from the time it was enacted, and never was intended to from the time it was enacted, punish the defrauding of someone of something that was inchoate, not tangible, and basically not money. So there had to be some kind of, if it involved a bribe, some kind of money involved, some kind of fraud that extracted money from someone, but money was the gist of it, and you couldn't be convicted simply for depriving someone of the right to good government. It was too nebulous. So I had just been appointed. I was about a year or two, I guess, in office, and here comes the writ for coram nobis. I think Arnold Weiner filed it.
He had the good thought to hire Arnold Weiner for that one.
Yes, so Arnold Weiner filed that, and eventually it was followed by others. And of course, writs of coram nobis are rare. You get a lot of writs of well, what are called 2255s, which are post-conviction review for federal prisoners, and then habeas corpuses for certain other prisoners, state prisoners. But quorum, and you can't do those, as you know, and I know, you can't use those writs unless the person's actually in custody. But there's another one called the writ of quorum nobis, which was one of the ancient writs of the high courts of England, and were brought over here when they came over, part of received law. And the miscellaneous writs, the federal judges still had the power to issue those miscellaneous common law writs. And the writ of quorum nobis simply is there to correct a conviction for which there is no other remedy, and a conviction that was void at the time it was made. Well, the thing was very heavily fought by Breckinridge Wilcox, who also is not any longer with us, who was then U.S. Attorney. And I wound up having a hearing on it and writing a very long opinion on it. I've got to bring this up because funny things do happen. I would write, and my law clerks would edit it, and Bridget Rohde, who is now in private practice, who was the chief deputy, I think, assistant U.S. attorney in Brooklyn for after she left me and after she left Piper and Marbury, was one of my law clerks at the time. And I was a pretty careful editor, and had her edit, and then I would edit, and then she would edit what I edited, and then I'd edit what she edited. And just as we got it ready and final, I had, all right, Bridget, this is the last one. And she looked at me and said, buddy, you better be right about that. So after that, Sue and other people, Nora and other people in the office started calling me buddy. And that persisted for a long time. But in any event,
yes, it did.
So I issued the opinion granting the writ of quorum nobis. And I remember it hit the Evening Sun, which was then in business. It has gone out of business since. And it hit the Evening Sun, and there was an editorial in there by a guy named Ray Jenkins, also dead. And Ray excoriated me for handling this case. He said, after all, Marvin Mandel has been found not guilty. How could you possibly say he was not, or has been found guilty? How could you possibly say he was not guilty? And of course the explanation was, well, what he did wasn't a crime. It wasn't a crime in the 19th century, and it wasn't a crime in the 20th century, and it's still not a crime. Well, later Congress did amend the statute to take into account the Mandel thing, but obviously couldn't be tried again. So I had a little fight with the publisher of the Sun, Evening Sun, who told me, he said, we don't care whether what we write was right or wrong. He's dead too. We don't care what, I'm just talking about a lot of dead people so that they can't come up and say, no, you're wrong. He said, we don't ever retract anything we say in an editorial. But Doug Khanna, who I think is also dead, was then the representative, legal representative. He was at Venable for the Sun paper. So he fixed a nice lunch for Ray and myself to shake hands over, and we eventually became friends. But in any event, I did get Ray to admit. I said, Ray, when you wrote that editorial, had you read what I wrote? He said, no, we didn't have time for that. We had the deadline, but I ripped something off the wire about it and wrote on that. So in any event, we did eventually make up, but I still didn't buy the Evening Sun until after it went out of business, and then I didn't buy the Morning Sun, but that's still in business, so I do occasionally read it. I have the subscription on the internet now. Anyway, so that's the Marvin Mandel story, and then it actually went down to the Fourth Circuit. Breckinridge Wilcox decided to take it to the Fourth Circuit, where it was affirmed, I think, on a 4-4 split. Didn't go to the Supreme Court. So in any event, some of the judges on the Fourth Circuit thought McNally probably wasn't good law, I guess, or whatever. And that was the Mandel story.
Did you expect that much criticism?
Oh yeah, I expected criticism from the Sun paper. Are you kidding?
They were in that business at that time?
Yeah, and if the News Post had still been in business, they would have done it too, or the News American, they would have done it too. And there were, I didn't get much I got hardly any mail on it. I got 1 or 2 letters on it, but a lot of people thought that Marvin had been done ill by. A lot of people thought he had deserved to go to jail. So, you know, it's like anything else. Always in law, 3 sides, your side, my side, and the right side.
And then I understand you also had an important case that just recently was decided by the Supreme Court.
Yeah, it took them about, 15 years to reverse me. But I had, had wondered why the court had never had the issue, and it had to do with the Confederate license plates. And the sons of the Confederate veterans had affinity tags, as did many, many other organizations, including churches, which displayed Bibles and crosses and other affinity, whatever their particular affinity was, maybe the Air Force thing for the Air Force, the American Legion, or whatever their, not their motto, but their what would you call it? Their sort of their logo, I guess. They would have their logo on the print, and then printed on the plate. It cost you $25, and you would get that, and then it would have the name of your organization on the bottom of the plate. And a lot of people like these things, and the Sons of the Confederate Veterans put in for it. They were granted that, and the logo they used was the Confederate battle flag. And this offended a number of people, so they bought suit, and we had litigation. The Motor Vehicle Administration, on the suggestion of some of the people in the state legislature, stopped issuing these and recalled the ones that were out there. Of course, the Sons of the Confederacy thought that violated their First Amendment rights. It was litigated. I issued an opinion that said that this was not government speech. It was private speech because the person chose what was going to be on their car, and they paid $25 for it, so it was not a gift from the government by far. And went into a very, I thought, complex analysis, which was upheld in most of the courts that looked at that particular issue. But then, times change and things change and justices change. And by the time it finally got to the Supreme Court just a few years ago, they said, no, it's government speech. What's on a license plate is government speech, and they can say whatever they want. You have to, or you want to buy your license plate thing and pay $25 for it, it's still government speech, even though you had the right to say what you wanted on it. They still can control it and whatever. So that was that. But I didn't like any decision that you make. As Judge Northrup said, you have to be decisive. I was decisive. 20 years later, I was wrong. So there you go. And I don't mind saying it was a close case. It was a very, very tight case, very close case. The idea being that, it certainly, I knew and was very sensitive to the fact that seeing that Confederate battle flag offended people. On the other hand, there were religious emblems of religions that were displayed that offended other people. Now, if there had been, for example, Sons of the SS or something with a swastika or ruins on it or something, maybe that would have been a different story. But even then, that probably would have prompted. I basically said that the NBA had 2 choices: either they let these people or other people that pay the fee and pay the $25 put on there what they want, or they just don't issue them. But having the state say, well, I like this, but I don't like that, was the major problem. But what the Supreme Court eventually said was, well, the state owns the license plates, they put on there what they want. So, and that is defensible, certainly.
That one took a long time to get around.
It did, indeed.
So you had the honor of serving with some pretty incredible judges that you've described.
I did.
Tell us some advice that you got from some of those judges that you used when you were on the bench.
Well, Stanley Blair said, you've got the best job in the courthouse. Do you want to switch? And I said no, and maybe as I look back on what's happened to the U.S. magistrate judges, maybe I should have stayed where I was. That was a great job and still is a great job. Norman Ramsey. Norman was, again, sui generis, one of a kind. He was a phenomenal person, and probably the lawyers that were in trouble would go to Norman Ramsey because he was the lawyer's lawyer. And I remember before he retired, he and I sort of sat around, and at that time Congress had frozen the salaries for years because they didn't want anybody to make more than they do, and they still didn't. But now we have a law that, well, not a law, we have the Supreme Court who said that you can't, this linkage thing doesn't work anymore, and now judges do get increases in their salary as a result of the Federal Circuit's decision, which the Supreme Court did not touch. It was a pretty sensible thing for them to do because there's no winning on that one. In any event, so, you know, and I was thinking about maybe leaving and going to the private sector, and Norman was right around 70 to retirement time. There's something called the Rule of 80. You have to be, if you're 70 and have 10 years in, or above 70 and you get to a total of 80, then you could retire. Norman had been in World War II and had almost everybody else that I worked with. In fact, everybody that I've worked with. Herb Murray was a bombardier in World War II. Let's see here. Ed Northrop was a naval officer. Joe Young was an infantry or engineer officer who was one of the first to cross the Remagen Bridge. We had some really fascinating people. Who else? Well, they had all been. Norman was a Marine Corps officer in the Pacific, and it just sort of went on. But anyway, and Stan Blair was, I think, in the Merchant Marine, U.S. Merchant Marine. Anyway, so Norman said, well, you know, he said, we probably, if you or I went to a law firm, we'd probably wind up working 20 hours a day, 7 days a week. We'd have a lot of stuff put on us to do. And he said, you know, I just don't think it's really worth it in the long run. So I stayed here, and Norman retired, and he went back to his old firm of Sems, Bone and Sems, and within 2 or 3 years after that, unfortunately, he was found slumped over dead from a heart attack in his car parked outside of the rotunda up in Roland Park. And I think he'd only been maybe 2, 3, 4 years retired at Sims, and I think he was sort of one of the laboring oars there. So that was probably pretty good advice from Norman too, because I'm still alive. So, and that's why you're doing this. One never knows. So that was Norman. Walter Black, consummate gentleman. Ben Legg, who is still alive, and I will speak good of Ben, because even if he were dead, I would speak good of Ben. He's just a wonderful guy, a gentleman through and through, and fantastic lawyer. So I was lucky to have worked with some of the finest people. Joe Howard. Joe was a very, very likable guy, and easy to, and he was a Army captain in World War II. And it was not easy for black officers in World War II, or for black soldiers either. And John Hargrove was a sergeant in World War II in the Army, and they had a hard time of it, but they carried on and carried through, and they both became terrific judges here.
I understand that in 1989, the court celebrated its bicentennial.
It did.
And you were appointed the chairman of the bicentennial celebration.
Because I was, and still am, fascinated by legal history, and I still teach. I haven't taught American legal history for a while, because most American legal history courses and books are essentially constitutional law light. And they're going to get it anyway. I do teach, and I have taught, and probably will before I retire from teaching altogether. I'm probably going to bring back a seminar on English legal history. And last time I did it, we got from the time of King Canute, which was 1000 AD, to, I think we got finished up Lord Mansfield, which is essentially when the absolute height of the common law. Common law was in its finest flower at the time of Lord Mansfield, about the time of the American Revolution until 1854, when Congress started, not Congress, when Parliament started meddling with judiciary matters. But that's another story, and for another country.
Well,
but I was interested in legal history and what happened here.
And during that time frame, I understand that you made a discovery.
I did make a discovery. Dave Owen, who is unfortunately also not with us, who was also very interested in legal history and the history of this court and admiralty history. He's an admiralty lawyer, and he had been a naval officer in World War II. And I've got to digress for a second because there was a great story. He and Norman Ramsey, when they were both in the occupation for a while of Japan, and they were finally being repatriated. They were on the same troop ship coming back, and David was a naval lieutenant, and Norman was I think he was a first lieutenant in the Marine Corps, they of essentially equal rank, maybe. And they were standing next to each other. None of them knew the other, and they were standing next to each other. I think Norman says they were just at the rail looking over. I think they might have been actually doing more than that. The rail, the Pacific, despite its name being calm, sometimes isn't real calm. So anyway, they were standing next to each other, and they started talking, and one of Dave Owen said to Norman, he says, where are you from? He said, Baltimore. And Dave Owen said, well, yeah, me too, or I live there now. And they met by coincidence. They eventually became lawyers at Semmes, Bowen and Semmes, and leaders of Semmes, Bowen and Semmes from that happenstance. Wow. Right on the troop ship. In any event, so we were at the, Dave Owen and I were the co-chairs of this. They wanted one judge and one civilian. So Dave and I met in my office, and I said, Dave, you know, I remember in the old building in the vault there was a bunch of old documents that I got a glance at one day. I didn't have time to look at them, but they were in the old building, and I hoped they came over. So I went up to the fourth floor and Paul was still there, Paul Schutz, and I said, Paul, do we have any of, you know, I remember in the old building we had a bunch of old documents. Did we bring them over? And Paul says, I think so. In fact, at least I said they ought to come over here. Let's go look in the vault. And it was a big vault, about half the size of this room. Still there, I'm sure, the walk-in vault, big walk-in vault. He says, well, I think maybe here somewhere. He started rummaging and moving cartons
Still back
and stuff.
at the old building?
Well, this is in the new building.
Oh, in the new building,
We were in the new
okay.
building in '89. And so we're in the vault, and he says, here they are. And there was this box of, I don't know, cornflakes or whatever it was. And inside of this cardboard box, opened it up, and here's this, you could tell, old documents. So he took them out and started looking at them. And the first thing I picked up was in folio, in long fool's cap vellum. In those days, they wrote on sheepskin. Vellum, fool's cap, or parchment, one or the other. And it was folded, as they did, into threes and tied with a red ribbon. And I looked at the outside, and it was all handwritten. It said, ex parte Merriman. Well, of course, that's one of the first cases you learn in law school. It has to do with the suspension of the writ of habeas corpus during the Civil War. And Merriman was a member of the Maryland militia, which about a couple hundred years later, 120 years later, I got to command, but that's another story, another era. So anyway, he was an officer of the Maryland militia, and he was ordered by the governor to go out and to get his cavalry troop together to burn down the bridges on what later became the North Central Railroad. Was then, I think, the Philadelphia-Patapsco something railroad. Came down to the station on President Street, which is still there, I think. It's a museum of some sort now. And in any event, he was told to take his troop out. And at that time, Maryland was a very southern-leaning state. We had slavery in this state, and the governor was southern-leaning, as was the police commissioner, as was the militia. So Merriman gathered up a bunch of the local gentry that were members of the militia. They went out, they burned down the bridges so that the railroad couldn't get the troops through and stop the Yankees from invading Maryland. So the Maryland military governor, northern governor, Union governor, was not happy about this, and he sent out troops, and they arrested the Maryland militia, including Merriman, who was very wealthy, had a huge plantation called Hayfields, which is still there. It's now a golf course, very like within walking distance of where I live in the North County. Anyway, so Merriman was clapped into the dungeon at Fort McHenry, along with some other people. And he had some good lawyers here, and his lawyers sued out a writ of habeas corpus in the district court. Well, in those days, there was no circuit court or court of appeals. There were circuit justices, and Roger Brooke Tawney was the circuit justice for Maryland. As such, he had the powers of a district judge and of a Supreme Court justice, and the powers to sit on appellate review. In those days, judges could sit on the appellate review of their own cases, which would be pretty nice, which was also actually the case in England under common law. Usually they said they were right the first time. But in any event, Tawney took the case, and he heard the case, and he issued a very famous opinion, which is part of constitutional law, saying that Lincoln did not have the power to suspend the writ of habeas corpus. And at the end of it, he said something to the effect of, now, I could order the United States Marshal to serve this writ, but if he went to Fort McHenry, he would probably be outgunned and outmanned because the general has a lot of soldiers and the marshal has 2 deputies, something to that effect. So it was essentially done to get something out in the public sector that would hopefully, and he said a copy of this will be sent directly to the president, hoping that the president would change his mind. Well, of course, the Attorney General at the time, who was a presidential appointee of Lincoln, looked at it and said, oh no, forget it. And that was the end of that until it became part of the law of the land that people look at. So anyway, I thought, well, it couldn't be the real thing. Untied it, a little red string around it. I remember to this day. Dave and I were there on it at a table. We untied it, unfolded it very carefully, and sure enough, it was the original opinion of Chief Justice Tawney in the Ex parte Merriman case. It was written in that beautiful copperplate script that they used to use, obviously not written by the justice himself. In those days you had scriveners who would, the justice would dictate or write, and then the scriveners would write it out in this beautiful print, beautiful handwritten stuff. And I've forgotten how long it was. And we leafed through it, and at the very end there was signed in very sketchy handwriting because Judge Tawney was then very old. He was in his 80s. He lived on Fayette Street at the time. I just walked to the courthouse. And there was R.B. Tawney, Chief Justice. So I said, David, we've found the original opinion in Tawney versus, in Ex parte Merriman. We couldn't believe it. And then we looked some more, and we found the docket and the papers in the first case ever filed in this court in 1789. It was an admiralty case because admiralty was the major, the bread and butter of the federal courts. The federal courts had so little work, it was very hard to get judges to take the job because it was so boring. There was very little work to do. It was almost all admiralty. There were still letters of marque and reprisal in those days, and all other kinds of admiralty matters, arresting ships for unpaid maritime liens, which we still do. Marque and reprisal we don't do anymore, of course. So we had that, and when we had writs of appointment of marshals and other officers of the court. None didn't find any commissions of judges. They generally tended to take them home with them, but signed by Andrew Jackson, Monroe, and Madison, and it was astounding. It was a treasure trove. So
what was the condition of the items?
As new.
Wow.
As new. Fortunately, you know, the vaults, I think, had been sort of temperature controlled and humidity controlled so that they preserve things. And there's a follow-on story about that I'll tell you in a minute. In any event, we saw all this and it was astounding. And the question, of course, was, why wasn't this in the Supreme Court archives? And a number of people have asked me that, and the reason is because it was not a Supreme Court decision. Law students who read it and are taught it think it was a Supreme Court decision because it was signed by a Supreme Court justice, but it was a decision of the U.S. District Court. So it stayed here, and somebody had the smarts not to send it anywhere. All right, So the tie-in is, after this, we all decided we should probably send these documents to be taken care of, archived, preserved, you know, put them in nitrogen or whatever they do, just to make sure that they stay the way they are, and they're in beautiful, beautiful condition. Anyway, and the old sheepskin stuff stays good because, you know, they don't have silverfish eating them and stuff like that. So I wrote a letter to the head of the National Archives at the request of when I became chief judge, the request of everybody. We all agreed to it. Would you please we send these to you, would you please preserve them appropriately and send them back to us, because we were planning to start a historical museum and we would like to have these. And I didn't send anything with it, just the letter. Well, about 2 weeks later, I got a letter from the director of the National Archives. It says, thank you very much for your inquiry. These documents all belong to us. Please forward them immediately to such and such an address where they will be preserved and maintained. And I said, not on your life, pal. We're not going to do that.
All these years.
No, we're not going to send them to the National Archives because we'll never see them again. So I took it up here, and we all agreed that the course was just to ignore the letter. Well, about every 6 months for 3 years, I got a letter from this guy at the National Archives saying, when are you going to send over these documents? And I just put it in the, you know, there's a sort of third thing in your desk, in, out, and DND. Do you know what the third desk is?
No.
In, out, DND is the third desk. That's die a natural death, where you want to put papers that, you know, go away. So I went into the DND desk, and eventually got tired of stopped bugging me to send stuff over. And now wonderful people like Herb Better and others have had them taken care of by archivists, and so we still have these. But it was really terrific.
Are they just on display anywhere now?
I'm not positive where they are. I think I know they come here occasionally for display, and Herb Better would be the better person to ask, but he's not being interviewed today, so you'll have to find that out.
Well, thankfully they were discovered.
They were discovered before somebody came in and said, oh, you're going to get rid of all this old junk. We got to make room for the old files and whatever. In those days, the vaults were filled mostly with sealed files. Because in those days, the Fourth Circuit had not yet mandated that everything that filed be public in a case, which they did based on something that I did, but that's another long story. That's every good deed or no good deed goes unpunished. Mm-hmm. The Fourth Circuit's major opinion saying that you cannot, I forgot the name of the opinion, that you cannot file papers under seal that are filed as affidavits or exhibits for motion for summary judgment, even if they have material in them, unless it's truly privileged, attorney-client privilege or something. But if they have sensitive material that might harm someone economically, et cetera, trade to the extent that the Trade Secrets Act doesn't apply, trade secrets, et cetera, or embarrassing things, for example, or settlement terms, you can't file them under seal. Well, we used to file them under seal all the time. There would be a consent order come in from counsel, said, please file this under seal. Judge would sign it. So one time in the summertime, John Hargrove's on vacation. I'm the chambers judge, which means I got all the stuff that came in, just the routine stuff. And there were always 3 or 4 orders to seal. So I signed the thing, seal it. So, of course, the Sun papers filed a suit wanting to get to the stuff. It went to the Fourth Circuit, and the Fourth Circuit excoriated me for not holding a hearing and looking into all of the First Amendment things before I signed the order. Well, of course you don't, because it's among the other pile of orders that you signed, and John was on vacation, so I had the duty. And I never forgave him I did forgive him for it. But every time I said, John, if you go on vacation again, I'm not taking your chambers work, pal, because I don't want to get excoriated by the Fourth Circuit again for how dumb I am and not holding a hearing that I shouldn't have held. But that's another story. Anyway, so.
So my recollection of our time
May I
together,
have a little sip of coffee here?
Please do.
Thank you.
Was that your efficiency was a great attribute of yours, along with many, many other things, and that you never had any issues with having too many cases on the report card or sitting around too long.
No, once again, I think that was from Judge Northrop's advice to be decisive. You know, one of the things I sometimes say is, I sort of made this one. I make up a lot of sayings. Most of them don't go anywhere. One of the ones I like to use as a judge, I get so tired of saying, you know, people say, well, what do you do? And if I say, well, I'm a judge, or I was a judge, well, then they get, either they're frightened of you, or they feel like they ought to bow down and, you know, kiss your shoes or something, or it's ridiculous. So I finally focused on saying, I'm in the business of hindsight blame assessment. Now that one worked pretty well. But, you know, Judge Northrop saying be decisive, and I found that very few things, and especially cases that you have heard or that you've had motions in, et cetera, get better with age. The only things that get better with age are some cheese, some very expensive wine, and a very few people. They get better with age. Cases don't get better with age. So it's good to attack them while the iron is hot, get them done and get them out and get a decision made. You strive to get it right, but then of course, what's right? You know, you try to do justice. I always remember seeing in the Supreme Court, in the conference room, the first time I went there, I had a occasion to go there for something or other. When you get the baby judges school, they call it. They have a big reception, and it's a lot of baby judges out there. So maybe you'll be there one day. So I hope, if that's what you want, and you want to be not rich. But in any event, in there they had a picture of John Marshall, beautiful portrait of John Marshall, and his hand is on a book of some sort, his finger touching the book, and it says, fiat justitia, which means do justice. And that is the be-all, the end-all, and the make-all of the law. We try. Do we achieve it? Sometimes. Sometimes it's not achieved. Whose fault is it? There has to be a system until they figure out a guilty meter, like you do with a kid when you stick a thermometer in their ear and you press the button and find out what their temperature is. You don't like it when it turns red. Well, until there's a truthometer you can stick in somebody's ear to figure out what's true and what's not true, we have to rely on our systems of adjudication. And although of course, criminally, the jury has not disappeared in this country, will not, I don't think. In England, it has disappeared to an extent, but it's still there for major matters. And it's funny, in England, the punishment or the court that you are sentenced in, and the mode or that you're tried in, and that the mode of adjudication, jury or non-jury, is not necessarily dependent on the crime, but it's dependent on the degree of punishment that is sought by the Crown. So you can be punished for what would otherwise be a fairly major crime if the Crown was only seeking a minor crime in the quarter sessions or in the Crown Court, County Court. Very different system to ours. But as you well know, you probably know this because I told you, but it's not well known in this country, and most law students don't understand it. And in England, where the jury system was born, it's essentially been done away with in civil trials. There are no civil trials left in England except for defamation, and the reason for that is because they figure that a jury will be more sensitive to the essence of defamation, which is the damage of someone's reputation in the community. So there, a jury is still brought in for malicious prosecution and for certain very high-level fraud crimes. Other than that, there are no juries. And in fact, in 1968, I think it was Ward versus James was the name of the case, one of the high court judges said that it is an abuse of discretion for a judge to impanel a jury to hear a case involving personal injury because juries are too unreliable in assessing damages. And that was the end of that. So sometimes where you don't have a written constitution, you ask an English lawyer, what's your constitution? Or if you're ignorant coming out of law school and you're an American lawyer, say, well, England doesn't have a constitution. And what you would hear is, my dear boy, we do have one, but unlike yours, it's not written. It just sort of is. So here we still have the system, the jury system in civil cases. People ask me, do you think that they came out with a just result? And I think in almost all cases, I probably would have done the same thing as most juries did, criminally or civilly. There was a few.
You just anticipated my very next
Yes.
question, which is about jury trials. And
yes, and in my time here, I don't think I ever granted a motion of acquittal.
after a verdict?
Wait, I think you can't do it after a verdict.
You can take it from, well, do you
Yes,
recall?
after there's, as I understand it, maybe the law has changed, but if you give a judgment of acquittal at the end of the prosecution case, it's not appealable by the prosecution. So it's a final order. If you give a judgment of acquittal at the end of the entire case, the government can appeal that. I think that's still the thing. But, and I don't think you can give an NOV in a criminal trial. No, I know you can't. But in a civil case, the equivalent, if you don't like what the jury did, NOV, and I only NOV'd one case, and that wasn't on a question of law, that was on a question of, a question of fact was a question of law. I shouldn't have let the case go to the jury.
Got it.
In the federal courts, we're much more proactive with summary judgment. In the state courts, from the appellate courts on down, there is more of a being very wary of summary judgment, so that what happens is cases go to trial, and the NOV is essentially a judge saying there was not enough evidence to take this to trial, which says, to me, well, why didn't you give summary judgment to begin with? But in the federal system, summary judgments are more frequently given.
Speaking of folks like the marshals, what I recall from my time in the courthouse is that it's really a family here, and there are so many people besides just other judges that I'm sure impacted your career. Tell us about some of those folks.
Well, absolutely. I think the quality of people that are hired here through some marvelous, miraculous act of God is that they tend to be lovely, wonderful people and competent as well. And the people in the clerk's office that couldn't be nicer and hardworking, and it's a very difficult job. In the old days, it all used to be by paper, and there were reams of paper and gazillion boxes of stuff that you had to take care of and make sure everything was retrievable at the right time. Of course, now since everything seems to be electronically stored, there probably is a lot easier way to take care of all the influx. But also the United States Marshals and not just the marshals themselves, but the deputies who provided security for us in court, the actual line deputies, and then the deputies who are the court security deputies who keep us all from harm's way, and just all marvelous individuals. And the U.S. Marshals are noted here for their longevity in office, because the U.S. Marshal is, of course, a presidential appointment. And we've had a few that have ridden out successfully several changes, major changes of political administrations, and I'm thinking of Ben Spurrier. And Ben was, I think, appointed in a Republican era, survived a Democratic one, and then another Republican one, or vice versa. And now we have Johnny Hughes, who is a fantastic, wonderful U.S. Marshal, who was appointed in a Republican administration, went through 2 terms of a Democratic administration, and I assume he will also be in the Trump administration for as long as it's in office. So our marshals, and that's a good thing, because we have that kind of continuity, and we have that kind of understanding all of the way the judges think and work, and what they need in their courtrooms, and what they need in terms of assistance. And of course, the United States attorneys, we've had some absolutely wonderful U.S. attorneys here. And I'm thinking of, I'll go back to the old days, because I don't want to discuss the people that are still around practicing law, although they're wonderful people too. But we've had, well, I'll mention Rod Rosenstein, because Rod apparently, as we speak, has just been voted favorably out of the Senate committee for confirmation as Assistant Attorney General, which would be a fantastic accomplishment for him. And he had a very long tenure here as U.S. Attorney, which was even more unusual than a marshal having long tenure. But we've had some terrific, and I'm thinking about the people that I knew a long time ago, in particular Jerby Finney, who was just a magnificent man, wonderful person, and also George Bell, and I had the utmost respect for George Bell. George is just a lovely human being, and a wonderful United States Attorney. All just terrific guys, and it's been a solid line of good United States attorneys, reasonable, hardworking, and I think truly embrace the idea of justice within the balance of the law, and it's important. And they've had wonderful assistants too, including the person I'm talking to, who was one of my wonderful law clerks. And I was lucky to have a tremendous, wonderful bunch of law clerks. Secretary Sue Parker, whom I stole from Jim Galeese, who I think now has passed on. When I was in law school, worked at Piper and Marbury, and knew Jim Galeese. Jim was new there. Paul Niemeyer, I think, had been there 1 year. I was just finishing up law school, and I stole Sue Parker, who was my secretary for almost 30 years, from Jim Galeese, and Jim never forgave me for it. Every time I'd pass him on the street, he'd take his pipe out of his mouth and he'd say, "You know, I've never forgiven you for stealing Sue Parker from me." I said, "I know that, Jim, but we're friends nonetheless." And so we had, and Nora, wonderful Nora, and I know I'm leaving Chris, who unfortunately is no longer with us, and my law clerks who've gone on to become fantastic judges and lawyers. And the thing about the law clerks is that I knew that practically everybody who applied, in terms of their abilities and skills and what they learned in law school, you could put in a paper bag, shake them up, put them, spread them all over the floor, pick one out, and they'd probably be as good as the next one. But what I was really interested in was somebody who'd be a good team worker, somebody who, when everybody else was busy and the phone rang, it was not infra dig for them to pick up the phone. Or when the coffee pot needed cleaning, they would clean the coffee pot. Or the mouse died inside the toaster, which happened to us a couple of times, and I remember Nora shrieking. I had a good law clerk who would go in and get the mouse out of the toaster. It was a toasted mouse by that time, and throw it in the trash can. So, a team player.
I always thought that you hired me solely for my resume.
Well, that, and I also figured that if another dead mouse showed up in the toaster, you'd probably go in and get it.
I'd have gotten them. So you retired in 2003, and at that time were the chief judge of the district court.
Yeah, I had some major physical problems, and my physician said, you probably should retire at this point, so I did, but I'm still alive, so he's kept me going.
Well, and
for
luckily,
which I'm very grateful, Doctor.
And luckily for aspiring law students who are aspiring to be lawyers, you have given many, many years to education, both at the University of Maryland School of Law and University of Baltimore. Are you still doing that as well?
Yes, I'm still teaching at the University of Baltimore Law School, and it's a great place, a great bunch of colleagues and students, and many of our students do not come, unlike Maryland. I don't know how University of Maryland is today, but at the University of Baltimore, a lot of our students come after another career or part of another career, and they've had some worldly experience, and they are very good at seeing things not just from the academic perspective, but from the perspective of life and how you deal with people and how you deal with problems and situations. So it's a pleasure to be teaching them, and I've taught. When I got to the University of Baltimore, I said, well, I'll teach almost anything you've got except tax. I I can't do tax. I do TurboTax. I can't figure it out. Intellectual property, I've had some patent and copyright cases, but boy, I sure am no engineer. When I was at Hopkins, I thought for a while I might want to be a doctor, and then I found out that the organic chemistry lab was at 8 o'clock on Saturday morning, and there's no freshman in the world who wants to go to a lab at 8 o'clock on Saturday morning. I mean, come on, give me a break. So that was the end of my career in anything scientific. Over the years, though, I have been very fortunate to have the ability to teach a lot of students, and they have turned out to be wonderful people.
And you're also spending time in mediations.
Yes, I do some mediations and arbitrations, and sadly, as we sit here, just preparing for the funeral of in England you would call them barristers' chambers, you would call him the head of chambers, who was Judge Howard Chasanow, the retired judge of the Court of Appeals of Maryland, and the spouse of one of our chief judges and former U.S. magistrate, Debbie Chasanow, who just tragically passed away on the eve of his 80th anniversary, 80th birthday, a day or two before we were sitting here talking. So yeah, I am doing some of that, and my former colleague here, Ben Legg, is also a colleague in doing that. And so we have still keep our fingers in the law, and it keeps you current. And you know, that's the nice thing about this business. There's always something new to learn. No matter how old you get, no matter how long you do it, there's always something new. And like they say in the TV ad for the PBS network, you have to stay curious. I think all the good lawyers I know are curious, and that is something that you're born with. There's a German word that describes, and I can see it in the law students, the ones who are going to be great and the ones who are going to be good and maybe great. But the German word is das Fingerspitzengefühl. It's a very long word, and it means feeling in the fingertips. When you have the feeling in your fingertips for something, and it describes the way some people are, and they're lucky enough to be that way. And when I look at people I've known in the law and people we've talked about today, immediately come to mind Norman Ramsey, Ed Northrup, Walter Black, and the judges who were judges here years ago, Judge Chestnut and Judge Soper, the great judges of the court. I've got to mention one more Judge Northrup story. When he had first been appointed, he was, I think his hearing, his nomination was made maybe on a Monday. The hearing in the Senate, because he knew everybody in Washington, hearing in the Senate was maybe on a Friday, and they voted him out to a vote by the entire Senate that Friday afternoon, and he was confirmed the following Monday. So he was on the rocket docket for getting confirmed. You know, in any event, he had some wonderful stories to tell, and one of them involved Judge Soper, who was at that time a circuit judge on the Fourth Circuit when they only had 3 judges. And he had the 6th floor chambers, which you'd only get to through a back alley entrance, basically, on top of the ceremonial courthouse and the old courthouse. And then Judge Chestnut was still a district judge. And so Judge Northrup set up, he was from Montgomery County, from Rockville. So he set up a meeting with Judge Soper to come over to the courthouse and have lunch with him and make a call, a courtesy call on Judge Soper, who was then the circuit court judge for Maryland. Anyway, he goes up and he has a very nice conversation with Judge Soper. And Judge Soper was as were most of the judges then, very short, about my size actually. And Judge Soper had a nice conversation with him, and he said, I'm going to take you downstairs, and at lunch we're going over to the Merchants Club, and we're going to be joined by His Excellency Judge Chestnut. Do you know His Excellency Judge Chestnut? And Judge Northrop said, well, I've met him once or twice, and I think I had a case or two before him years ago. He said, well, let's go down to the chambers of His Majesty Judge Chestnut. So at that time, Judge Chestnut was in his 80s, I guess. So they knocked on the door, and they came in, and it was a very long room like this, and Judge Chestnut had a very imposing desk at the end of the room. And Judge Soper and Judge Northrop walked up to the desk. They didn't bow, I guess, but they, maybe curtsied or something. And he points to Judge Northrop, and he says, Your Excellency, this is Northrop. He's a country bumpkin and a Democrat. Turn around, Northrop, so he can see what a Democrat and a country bumpkin looks like. Judge Northrop said, I just did a little pirouette. And Northrop was the first Democrat and the first person from outside Baltimore City to be appointed a district judge since the end of the Civil War.
Wow.
Every judge after the Civil War had happened to be appointed in a Republican administration, and they were all from Baltimore. And Montgomery County was a farm county. Everything was a farm county except Baltimore City and even Baltimore County was a farm county then.
My, how things have changed in terms of
Well,
getting
a teeny
through the
bit.
Senate confirmation process.
Yes, a teeny bit. And we only had, when I started working for Judge Northrop, there were 3 judges here. There was Judge Russell Thompson, who was the chief, Dorsey Watkins, who was the senior, I guess, person, and then Judge Northrop, just the 3 of them. He was and that was a new appointment put in when the Kennedy administration first came in. So for many years before Prohibition, there was only 1 district judge. They had to put in a second when Prohibition came along. So there's an interesting story too there's so many stories here. This place is full of stories. There's a story about Judge Rose, who was a district judge who later became a circuit judge. And it has been said that there was a club called the 14 Hamilton Street Club, which is still a club, and I belonged to that for a while. So did Judge Northrop and a couple of other people, and had a lot of people from Hopkins and other vocations. Anyway, they apparently were going to something at a club, and there was a bottle or a case of wine. And the case of wine was sitting under the seat of this Ford that they were riding in. And Judge Rose was in the car. And of course, it was Prohibition time. You weren't supposed to have any wine. So they're driving along, and the guy who owned the car said, Judge Rose, I didn't even think of this, but you're sitting on a case of wine. And if we get caught, this is going to be horrible. He says, well, don't worry about a thing. I'll just tell the Prohibition agent that the case is sub rosa. No, they were quite something in those days. And the other thing about I remember about Judge Soper being told was that one time he was listening to an oral argument. Judge Northrop told me this. Northrop happened to be there. And he had a case before the Fourth Circuit down in Richmond. And they were listening to, there was an oral argument going on, and there was the question was the ambiguity of a document. And Judge Soper looked at the counsel who was making the argument. He said, well, if I'm not mistaken, counsel, you drafted the document in question. Is that right? He said, well, yes, Your Honor, I did draft it. And he said, and now you're arguing that it's ambiguous. And the attorney said, well, yes, I suppose I am putting in position of saying it's ambiguous. And so therefore, I suppose I have to admit that, yes, that it was a bit of ambiguity. And Judge looked at him and said, not only was it a bit of ambiguity, it was a masterpiece of ambiguity. And then, as he used to, he just turned his chair around and looked at the back of the bench.
That was the way to let him know it was over.
That's the way he did it. Yes.
Well, your stories have been wonderful to hear. I am so honored to have been able to do this.
Well, thank you, Ty. I'm honored you did it. And I've been asked for a while to do this, and I have been able to worm my way out of Herbie Better's many invitations to do this, because I sort of felt, well, you know, you shouldn't sit there and talk about yourself, but I've tried to talk more about other people that I knew than myself. And then he told me that he had recruited you to do it, and I said, well, I can't say no to Ty.
Well, that doesn't surprise me at all, that you would focus on others, given your kindness.
Thank you.
But I thank you, along with all of your law clerks, all of the lawyers in Maryland, and the citizens of Maryland.
Well, some of the lawyers in Maryland.
Some
of them who still haven't forgiven me. Thanks,
and
Ty.
for your distinguished service on the bench.
Thank you.